Welcome to Forums That Matter this morning, a community service of the Unitarian Universalist Congregation of Cleveland. I'm Susan Alcorn, a member of the Forum Committee and the coordinator for today's forum, which has both remote and in-person audiences. Our forums this fall are all related to democracy. Today's forum is titled Power by Pen, 160 executive orders, and you can see before long that that's increased. These orders reshape U.S. programs that are traditionally and legally under federal control. They target international agreements, climate, diversity and gender issues, immigration, education, and more. Many of these executive orders face legal challenges. If the courts cannot, and Congress and the Supreme Court will not hold the president accountable, has the separation of powers in our Constitution been destroyed? Let's share our thoughts and experiences on this morning. I would now like to introduce our speaker, Avidan, a Case Western Reserve University law professor. He's also the director of their Institute for Global Security, Law, and Policy. He currently teaches international law along with scholarship on human rights, civil rights, and national security. He has appeared in numerous media, including the New York Times, Washington Post, BBC, MSNBC, C-SPAN, and Fox News. Before our discussion begins, please be sure your phones are silent. If you have questions, hold them to our Q&A period, which is around 9 minutes. This forum is being recorded and will be available in a few days on our website. I now turn it.
Good morning, Susan. Thank you for inviting me. Thank you all for having me. I look forward to a wonderful conversation. And so if you'll indulge me to give a short presentation with a PowerPoint on some of these issues, I'm going to just share my screen so folks elsewhere can see everything. There we go. Okay, so yeah, you'll see by the title, when Susan and I first discussed doing this program, just a little over a month ago, we were at only 160 executive orders. So this number is probably incorrect as we sit here today, because I think this was only final through near the end of September. So I want to talk about executive orders. I don't want to necessarily be too limited by that term, because you'll often see, for example, executive actions described as being taken pursuant to a proclamation or a memorandum, or simply, we're not really sure. It sometimes seems to be a posting on Truth Social or X or presidential fiat of some sort. So, but I do want to talk specifically about executive orders as well. And so, you don't seem to be moving. Here we go. So here's our very brief agenda. I do want to give a little bit of an overview over what are executive orders, talk a little bit about, no doubt we hear seemingly every day about how President Trump is using these. Some of the unique challenges that I think are specific to President Trump, but also systemic challenges that raise issues about executive orders that could have been raised during the Biden administration or dating back to the Clinton or Bush or Reagan administration for that matter. And then talk a little bit about the prognosis, if you will, and maybe solutions, which I'll give away the closing here. I'm not sure I have any great solutions, and maybe we can have a good, robust conversation in that respect. So as is noted in the title, through September, President Trump has issued 206 executive orders. And as we were talking about just briefly before we began, I don't want us to get actually too focused on the number, because in many respects, what really matters more is the content and the character of these orders. There's an executive order that was passed recently that says the Department of Defense should now be called, as you know, the Department of War, right? I don't want to minimize the significance of that, but there are far more significant ones, right? There are often prosaic executive orders that announce, it's the month of X, Y, or Z. But there are some that are, of course, much more significant that impart radical changes on our society and have the impact on thousands, in some cases, hundreds of thousands, in particular, immigrants, but federal workers who lose their jobs. These executive orders have significant, real, terrible life impact. But for a point of perspective, because I did take a look at the numbers here, during President Biden's 4 years in office, he issued 162 executive orders. So in 9 months, we've gone well past that. President Carter, though, might surprise you, issued 320 executive orders during his presidency. And if we go further back, FDR, President Roosevelt, in his first year in office, issued 654. Well, now certainly we can recognize that was a different time, facing significant threats. So it's not only about the number, but do want us to have that perspective. So what are these executive orders? Because I think what is raised, and in Susan's introduction, right, we have concerns about separation of powers. These are directives by the president. In most cases, when we talk about executive orders, a directive to an agency, right? A directive to a department to implement something, right? And so it's actually not the order itself by the president that necessarily is where we get alarmed, so to speak. I mean, obviously that's the genesis of it, but it's when that agency acts on it. And we'll look at some examples of that. What is critical, though, is when the president acts for an executive order to be lawful, that source of authority has to come from either the Constitution, Article 2, which designates certain powers to the president, or from Congress, right, by a statute, which has given the president, has delegated or authorized the president to do certain things. And here is where, to some extent, the rubber can often hit the road, if you will. And I should say, as the slide suggests, right, the other important check, right, in addition to there being sufficient or a legitimate source of authority, is that it can't violate substantive protections that are provided in the Constitution. So even if Congress authorizes something, if it violates the First Amendment, that will still be declared unlawful, or should be, I should say, be found unlawful. So here we're going to have just the real primer, if you will, might bring you back to middle school, high school, college, what have you, but to remind us of certain of the powers provided in the Constitution. And again, as Susan noted, separation of powers is so critical here. So more often than not, we are really thinking about, well, what are the powers that are assigned to Congress? What are the powers that are assigned to the president through the Constitution? And so you'll see here, right, we know that in Article 1, Congress has the legislative power to make laws. It is the lawmaking body. It has the power to regulate commerce. It has the power to declare war. It has the power to make appropriations, the power of the purse, if you will, right? All of these sort of are provided for here behind me. The president, in contrast, is the executive. It's supposed to execute the laws. More often than not, when we're talking about executive orders, the president will place great emphasis on that last bullet, that the president is taking care that the laws be faithfully executed. That's often the assertion of exercising a congressional grant of authority. But the president will also put great stock in that first provision, simply this broader principle that the executive has the executive power. It is vested in the executive branch. And what that means, perhaps some of you are familiar, we've heard bandied about, for example, the notion of a unitary executive. This president has taken a very muscular view, if you will, of what executive authority grants, that it is both broad and a rigorous one. And we'll talk in a moment about that as well. I always like for perhaps people who remember their constitutional history, or certainly in this day and age, originalism in the Supreme Court is particularly in vogue. So as to remind us from the Federalist, right? This is written by James Madison, Federalist number 51, which reminds us of the importance of separation of powers, that divided government is in the interests of society, and particularly in the interest of the preservation of liberty, and can protect the minorities among us as well. That's part of the conceit of the separation of powers. A little law professor didacticism, but I always like this here because I think particularly we all appreciate any Ohio reference to law. So one of the critical Supreme Court cases, now almost 75 years old, is what is known as the Steel Seizure case, or the Youngstown case. This involved an executive order. It involved President Truman purporting to seize, I should say, the steel mills in Youngstown and in Pittsburgh as well. This was during the Korean War. There was a labor dispute going on. And President Truman purported to take, utilizing executive authority, to seize these mills, asserting a commander-in-chief power, presidential power, also asserted there was congressional authorization. And the Supreme Court, in somewhat of a surprise at the time, rejected his arguments, found that this seizure of the mills was unlawful. And one of the tests that has emerged, Justice Robert Jackson, prosecutor in Nuremberg, very influential justice, issued a concurring opinion, which to this day is really the framework by which we analyze, does the president really have the power he asserts? And it's a tripartite test. When we can see the president acting pursuant to an express or implied authorization from Congress, his power is at its maximum, right? We sort of say that, all right, he's got a good argument here, right? Congress, he can point to a congressional statute that authorizes him to do it. He's going to stand on pretty strong ground. In the middle, in Justice Jackson's colorful language, is a zone of twilight, where there's not necessarily a grant of power, but there's not necessarily a denial of power either. And so Congress and the president are sort of working in this concurrent fashion. Sometimes there's a tug of war, sometimes there's not. This is where really it matters, and this will be one of my themes, how much Congress chooses to act or acquiesce in the president's actions. And finally, when the president takes matters or measures that are incompatible, that is to say, in direct contrast and contradiction to either a limit on power or removal of power, his power is at its lowest ebb. It's going to be most often suspect. Rarely will a court find that such an action is lawful. There, you're looking at a fight, if you will, between their purported constitutional authorizations. But so this is the framework that really often you would expect a court to apply. So that's our legal background. Let's get into a little bit of what President Trump has done in these 9 months in office so far. So he's issued, as we said, over 200 executive orders. Amongst them, I'm sure many of you can identify others, but have purported to, and I say purported to because in many cases, courts have enjoined or stopped, blocked some of these actions, but purported to end birthright citizenship. He issued that executive order on Inauguration Day. Freeze foreign aid, right? Dismantle USAID, but not merely that. Eliminate or effectively dismantle the Education Department. Erase transgender people from recognition by the federal government. Restrict the availability of gender-affirming healthcare for youth in medical institutions. Ban diversity, equity, inclusion, and accessibility initiatives, particularly throughout schools, but not merely there. Targeting lawyers and law firms, right? Effectively requiring them to do work for the Trump administration, denying them security access or any access in some cases to federal buildings, and stripping power from independent regulatory agencies, right? This is just a brief, right, and snapshot of some of these orders. As you're well aware, immediately lawyers, I have a certain bias or soft spot in my heart since that's whom I train and have practiced law, have been perhaps the strongest bulwark against these orders. There have been over 400 legal challenges to these orders with mixed effect Certainly we hear a lot in particular about what the Supreme Court has done, which has generally green-lighted these orders through, again, a term that's gotten greater notoriety as of late, the emergency docket or shadow docket or interim docket, as it's been known. But these are instances where lower courts have generally, really quite on an incredibly broad and majority level, struck these orders down as unlawful or enjoined them. And the court has stepped in a very hasty fashion and somewhat surprising. And I would say, I don't want to necessarily get too political, but in a way quite distinct from what it did during the Biden administration, where it is jumping in and effectively lifting those injunctions and letting them go into effect and issuing very hasty rulings. In many cases, with absolutely no explanation of why that order should go through and is upheld. We actually have to rely often on the dissents for explaining a little bit of what's going on. And that we can talk about that in conversations. It's a very significant issue that we're seeing play out here. But I do want to note, even with all of that news, the Supreme Court's only addressing so many of these cases. And so of these 400 or so cases, in at least 130 instances, by at least one count, these orders have been blocked. In some cases temporarily. Almost half of them are still awaiting a court ruling, so we don't necessarily know the legal outcome of them. 71 have been allowed to move forward, and a variety of others sort of in process, if you will. So it's a significant development that sometimes doesn't get as much attention. Right? The district courts are stopping these, and in some cases, the Supreme Court is just simply not getting involved, or in some cases, the administration, knowing perhaps that it wouldn't succeed at the Supreme Court level, is not challenging those decisions. So those stories don't get reported, right, in action. But there is, I don't want to tell you the glass is half full, but there is some good news in some of those legal efforts. So let's look at, though, depending on our time, we'll see if we can get through 4 case studies, if you will. We can certainly talk about others in the Q&A. The first I want to talk about is the birthright citizenship case. So as I noted, on Inauguration Day, the president purported to eliminate effectively what had long been understood, really since the inception of the 14th Amendment, and certainly for 125 years, based on a Supreme Court case called Wong Kim Ark, which understood and directed and explained that the 14th Amendment does indeed establish birthright citizenship. The 14th Amendment should be seen as a corrective to what was the Dred Scott decision, right? A decision that Justice Roger Taney held meant that enslaved Black people, right, were not citizens, even if they were born in the United States. The 14th Amendment was a response to that, right, encoding birthright citizenship. This executive order purports to eliminate that. Even though it begins with acknowledging the 14th Amendment, it cites a federal statute, which effectively reiterates what is in the 14th Amendment, and, as I said, Supreme Court precedent. The argument that it makes within an executive order is effectively that this language, subject to the jurisdiction thereof, only should include people who are lawfully here, only the children who are born of parents who are lawfully here. And so the executive order, you'll see here, and here is how a good illustration of what an executive order does do in Section 2A, right? It is directing various agencies in terms of how they issue documents. This is how an executive order gets implemented, right? It's to say, you shouldn't issue a passport, or you shouldn't recognize a document that purports to recognize the citizenship of persons who were born to a mother unlawfully present in the United States, or a mother whose presence, and this is even more radical, in the United States was lawful, but temporary, right? So this, by executive fiat, by an executive order, purports to eliminate this, right? It is going against the Constitution, the understood plain meaning, I think safe to say, and even originalist understanding of the 14th Amendment. It is going against statute. It is going against Supreme Court precedent. This is a truly radical move. And what we have seen the court do, so you may know, right, that in June of this year, the Supreme Court sort of heard this case. The Trump administration had lost at every district court, regardless of which president assigned the judge on this matter. And what many of those courts were doing were issuing what are called nationwide or universal injunctions. Because the nature of this would be, right, they needed this law effectively to be stopped everywhere, right, because of the radical effect that it would have, upsetting really this interrelated set of states that we have and these dynamics. To some extent, universal injunctions, nationwide injunctions were always on the court's target list, if you will. There were a number of justices who had always expressed great displeasure in that. The idea that one judge should effectively throughout the country, right, stop a law, right, or an executive order was problematic. Now, what's interesting is these have gone on for quite some time. This is not something unique to the Trump administration in terms of nationwide injunctions. They were implemented during the Bush administration at quite a high level, during the Obama administration, during the Biden administration. The government or the Supreme Court never saw fit to use any of those cases, right, as a vehicle to eliminate universal injunctions. So only here with the Trump administration did they see fit to do so, which you might even argue this was the worst substantively type of case. This is maybe the strongest argument for a universal injunction when you have something that's going to affect people all over the country and really create chaos. Because the converse is a state of Ohio judge rules that this order is unlawful, but it is lawful in Indiana. Well, what happens when that person comes to Ohio and vice versa? So in any event, the court struck down not the substance of this law, but simply that this was the wrong vehicle that judges were using and that universal injunctions were no longer permitted. Ultimately, just so you know, because we actually have a decision as recently as Friday on this matter, litigation began immediately on this, and it's a little technical, but often, certainly many of you, I'm sure, have heard of class actions. So effectively, lawyers brought class actions on behalf of these people, people who would be subject to this order, and again, found uniform success in the courts where those have been litigated. As recently as Friday, the First Circuit, so that's the Court of Appeals, the Federal Court of Appeals that handles Massachusetts, New Hampshire, Maine, Rhode Island, upheld that class certification. So right now, effectively, the effect of this order is stayed. Right now, people are safe, if you will, and birthright citizenship can continue. It's likely that the Supreme Court that the administration will ultimately challenge this case in the Supreme Court. Though I don't want to say it's certain, because I think most, and I'm out of the game of prediction in this day and age, but most people seem to think even this court would find this order unlawful. But it is a useful illustration of how really just one person, granted someone who has been elected by this country, can affect such a massive legal and policy change that affects thousands and thousands of people's lives, and again, upends scores of years of understood legal practice and precedent. So that's just one example. Let me give you another example. This affects many immigrants throughout this country. Now, I don't want to sugarcoat. I think many of you are perhaps active in areas of immigration law. Immigration law, people are very vulnerable as immigrants to this country, period, under any presidency. There's a massive amount of authority that is given to the federal government, Congress, and president alike. But President Trump, and this is again a unique feature of his, I would say he was elected in some ways because of this by many, is a norm-busting, a norm-breaking individual, right? And so what he has done, is, the reason why I want to use this example is in some instances, we see instances where the president is acting what would seem to be against any and all congressional authority, right? The birthright citizenship is a good example. You have a statute that says something plainly contrary to what this executive order provides. But sometimes the president, and this is a useful thing for all of us to remember, there are a lot of laws on the books. Some of them have been on the laws for a couple hundred years that are pretty horrifying and don't necessarily comport certainly with our understandings of due process and fairness in the year 2025. Well, so in March, President Trump issued a presidential proclamation, really the same thing as an executive order, asserting the power to remove Venezuelan nationals who are members of Tren de Aragua, a designated foreign terrorist organization, mind you, designated as such by President Trump. And the president declared that the group is perpetrating, attempting, and threatening an invasion or predatory incursion against the territory of the United States, and doing so at the direction of the Venezuelan president, Nicolas Maduro. Well, where does the president get such authority to do such a thing? There is a law, goes back to 1798, called the Alien Enemies Act. And this is what the president relied on, which authorizes the removal of natives, citizens, denizens, or subjects of the hostile nation if there's a declared war with a foreign nation or government, or a nation or government that is engaged in an invasion of territory of the United States. So President Trump made a finding. There is an invasion, right, directed by President Maduro by Venezuelan nationals in the form of Tren de Aragua. Presidents have invoked this law only 3 times in the nation's history. These were all during congressionally declared wars. Right? Only those 3 times. But the president had asserted under this that the act grants the president unlimited authority to identify and countermand such foreign invasions. Now, there's actually one of the few instances where the Supreme Court did get involved, because pursuant to this authority, the administration was effectively going to deny any and all due process protection, right? Not even a remote modicum of any sort of hearing. And the court did say, no. There needs to be some sort of process given. So sent it back to the lower courts. It worked its way up to the Fifth Circuit Court of Appeals, which is by some characterizations known as the most conservative appellate court in the country. And in somewhat of a surprise, in a 2-to-1 ruling, the court looked at the president's determination of this invasion and found it lacking, right? That there was not a factual basis for finding there to be such an invasion. In dissent, Judge Oldham stated that a determination whether there's been an invasion or predatory incursion is a matter of political judgment for which judges have neither technical competence nor official responsibility, and cited a World War II era case that indeed has that similar language. This case will now be heard. The Trump administration sought review by the entire Fifth Circuit, what's known as en banc hearing, and so they will hear it. Again, not necessarily the most able predictor, but I would surmise that the full Fifth Circuit will find in favor of the dissent and find that indeed there is such an invasion. Could be wrong, may ultimately work its way up to the Supreme Court. But that dissent is illustrative of yet another point I want to underscore. While many things might seem quite remarkable about what President Trump is asserting, there is a long-held view by this court for presidents of both parties that when you get to an area that relates to foreign affairs, that can be quite broadly construed to certainly include immigration, the president has a great level of, in the court's word, unfettered discretion. Right? It's not the court's business to second guess the president. And that level of deference, which I have always argued in my scholarship and in advocacy, is way too deferential, is what I think will carry the day. And it's often the language, particularly in any immigration case you hear, the Abrego Garcia case that many of you are probably familiar with, the Maryland individual who was deported and sent to El Salvador to a counterterrorism facility. Often the court has said, even when the government's gone too far, says, well, let's let the judges issue this decision, but they need to be very thoughtful and solicitous of the president's discretion in this area, right? So that's a real concern. I don't know where necessarily this will go. I'm going to go through these couple other examples real quickly, but some of you probably have been paying attention to the tariffs that the president has authorized. These are pursuant to a series of executive orders, 5 executive orders in particular. They too rely on congressional authorities, specifically the National Emergencies Act and the International Emergency Economic Powers Act. Notably, actually, the IEPA law was something, or a precursor to that. was what President Truman also relied on. And here's also just, one of my admonitions about how much authority Congress does give away. Right? There are currently more than 49 national emergencies in this country, right, declared by presidents of various parties. Congress authorized these or gave the president such authority. Some of them have been going on for well more than 10 years. Right? So when Congress is in the business of granting, in many cases, very unlimited authority, presidents may use them. Some presidents may use them judiciously and responsibly and in good faith, but others will not. And here is a significant risk. Now, you can't read something into the statute that is not there. And so the Federal Circuit and the District or the Court of International Trade that heard these matters, right, have both found against President Trump. This will ultimately be decided by the Supreme Court. Oral arguments will be in November. But what the appellate court found was that, for example, in the statute, while giving the president quite a good number of authorities to address national emergencies, what is not listed there are taxes or tariffs. Nor has there been an instance of the president doing such, right? Identifying trade as a national security threat and emergency requiring these tariffs. So effectively, the court struck those down. And what they used was, interestingly, something called the major questions doctrine. The major questions doctrine is something that was really a pet project of Chief Justice Roberts and members, I would say, of the conservative Supreme Court members, that they used to strike down executive actions in the environmental space. And indeed, some of you may recall the student loans forgiveness that President Biden sought to authorize. In both cases, they found that was an overreach of executive power, that the legislature, the Congress, had not authorized such a significant change through such opaque language. And so what will be an interesting test, if you will, notwithstanding the significant import of these tariffs, these global tariffs, is will the court be faithful to the rules it has established for other presidents to President Trump on this tariffs case? Because I would say many commentators, I don't want to say all, would suggest this is a classic example. If you apply that doctrine, the major questions doctrine, it's really hard to square the circle and see how these tariffs could be upheld. But it would not be the first time the court has surprised us in some more creative lawyering. I mean, one of the principal arguments that the Trump administration has made effectively, but think of the logic of this argument. We have effected this radical global economic change. Court, you can't get involved, right? You will disrupt this state of economic affairs. And there's a certain potency to that argument. But also think of how problematic that one is, right? The president's always going to be able to get ahead of the courts. It's always going to be able to move fast, right? That's the argument in support of presidential authority, but it's also, it proves too much. Right? In the interest of time, I'm gonna skip one, but we can certainly, perhaps it will come up in questions. So I do want to just highlight in some ways the systemic and unique challenges we're facing here. So one is really that all presidents have often argued, and I alluded to it in the authorities that you see the Constitution grants to the president, right? There is this uniquely inherent executive authority, right? Only the president can act in such a singular fashion, right? When we need something to be done quickly, effectively, who's going to do it? Congress can't do it. We're 135 people. How are they going to act quickly, effectively? We give the president such authority, right? It's inherent in the vesting clause in executive power. The sole organ theory is something that dates back almost 100 years, particularly applied in foreign affairs, which basically argues in similar fashion, the president represents this country. And so, for example, we see the president is the commander in chief. Right? And in general, we say we don't second guess presidential decisions during war, during a battle. The unitary executive is a more novel theory, but one that I would say particularly certain members of the court have long sought to do. But here too, of a similar fashion, the idea is there's one president of the United States. And when the president comes to power and wants the Treasury Department to do something, it makes no sense that he couldn't fire the Secretary of Treasury, right? It makes no sense that he couldn't fire officers in the Federal Reserve, right? The idea is he is the unitary executive, the singular executive, and should be able to do all these And so when Congress legislates offices in some of those independent agencies that can only be fired, for example, for cause, that is an unforgivable, unconstitutional intrusion on executive authority. Now, I should note, because there have been a number of cases where the president is recently doing this, we can talk about it. Here too, this is a precedent that's existed for 90 years that has always accepted the idea that no, there are certain limits on what the president can do. We want there to be some independence in agencies. And so the president has been seeking to undo that. Finally, there's presidential immunity, which, while there was always some modicum of notions of immunity, you may, of course, recall that the Supreme Court waited a while to decide before the 2024 election, but in June of 24 ruled that the president enjoys absolute immunity from criminal prosecution for actions within his constitutional authority, and at least presumptive immunity for all other official acts. So here to consider, when the president effects pretty much any executive order or proclamation, that is at a minimum an official act, and so regardless of its potential illegality, cannot face criminal prosecution. That's a significant removal of a check on presidential authority. Now, I should note that does not mean that lower level officials could not be prosecuted for an illegal executive order. And I should hasten to add, in most instances, when we're talking about illegal executive orders, we're not usually talking about criminal prosecution. We would be talking about some sort of civil action that enjoins and simply prevents it. But that's a significant check. Well, last bit I just want to note, right, because I do think while this is not a unique concern, I do want to just underscore about President Trump. Our Constitution is relatively brief. And so there are gaps when we talk about separation of powers. What is quintessentially an executive action? What is quintessentially congressional or legislative action? There is vagueness. I don't want to pretend otherwise. And so that can often be a concern. Congressional abdication. Now, sometimes you have to be careful what you wish for. I don't know that we always want Congress to act. But in this space, the lack of oversight, the lack of assertion of its power, for example, the power of the purse and appropriations when the president is making unilateral decisions to rescind spending, right? Congress has effectively become a wallflower, right? It is sitting at the side while the dance is going on and the president is the primary locus of all action. That's not the way the system was supposed to be. The framers never envisioned such an anemic and sclerotic Congress, right? And that's the way it's acting. Now, that is certainly an argument for why we need, right, divided government in terms of, at the very least, having a different party, right, that can hold a president accountable, particularly one who is making such wide sweeping assertions of presidential authority. Another thing that I think we learned in the first Trump administration, but is even all too clear in the second administration, and I alluded to this, is that we expect, in general, our leaders, maybe naively, to act in good faith and in the interests of the whole country. I think it is safe to say that in many instances, this president, this administration is not acting in good faith. They are taking actions that they know are illegal, right? And the birthright citizenship is a classic example. That's such an outrageous action. And what you would expect is lawyers are telling the president, you can't do that. And we know, in some ways, there were government officials, White House officials in the first Trump administration who stood up to the president. Right? We're not seeing that in this administration, right? So they're not acting in good faith, and that's a great weakness. Supreme Court approval. I've alluded to this emergency docket, right? That the court is really of the same mind as this president in a broad assertion of executive power. And again, I think we've seen some inconsistency in the way it's applied some of those principles, perhaps more comfortable with a broader assertion of power by President Trump than, say, a President Biden. But this is a frightening set of developments. I think it is somewhat this court realizing an agenda it's long held, and it's realizing it through this president, which I think is also sort of more astonishing and worrisome. And finally, the electorate. I alluded to this before as well. We as a country voted for President Trump. President Trump did not hide his agenda. Right? He said he was going to, it's about as euphemistic as I can get, shake things up. But he is knowingly and promised that he would violate various norms, and he is doing so. And I think a significant number of members of the public are fine with that. Right? We see it in polling. about the desire for authoritarianism, ascendant views, that we should go back to a monarch. Right? These are really scary concerns. And while the court certainly doesn't speak in a language that adopts in any way a monarch, it is blessing actions that are all too representative of such. So I want to just end, I'm sure you all know this, but it really does come down to us, and it comes down to issues of speaking out, of protesting, of voting, of pushing our legislators to act, and for continuing litigation on these matters. But I do want to ultimately say this stems from, a popular zeitgeist, right? It falls on all of us, regardless of how you voted. And so as Benjamin Franklin responded to the query on the last day of the Constitutional Convention, what have we got? A republic or a monarchy? We have to tell ourselves a republic if we can keep it. Thank you, everyone. I apologize for being a little.
Thank you so much for that discussion. It's now time for questions and comments. Hold up your hand and we will recognize you. And please speak clearly into the microphone so our in-person and remote audiences can hear you. Those at home can type questions by using the Q&A button. Thank you.
Thank you very much for a very interesting presentation. I have a question that I've been thinking about for a long time. And I remember President Trump's comments regarding his views on a woman's reproductive freedom, which is, let's leave it up to the states. The notion of federalism and states' rights is based on the notion that fundamental rights can be taken away as long as the majority of people in the state approve of it. And of course, there might be some oversight by the courts, or perhaps not. But has the notion of states' rights and federalism still a good idea in a country that is 350 million people and increasingly diverse, and with racism and prejudice on the rise? Your thoughts, please.
Yeah, no, I mean, so certainly, on some hand, I don't want to be too cute, right? The view on federalism perhaps somewhat depends on where you stand, right? Literally, right? Like which state you're in and who's the president, right? I mean, right now, historically, we've certainly thought of federalism as something, again, synonymous with states' rights in a way of, for example, maintaining slavery, right? That's sort of the ultimate expression of states' rights, right? And then Jim Crow, right? And so we can certainly view federalism as that way. It's interesting, particularly during the first Trump administration, started thinking in a different way about federalism. I think, again, if I might frame, like a lot of people who might characterize themselves as liberal, right? Where if the federal government is going to take this muscular view and enforce certain laws, say on immigration, right? One of the issues where the idea of federalism is right now joined is with the notion of sanctuary cities, right? And sanctuary for immigrants. If the federal government, utilizing ICE in various ways, is now using the federal government to take a very expansive view of federal power and restrict people's rights, right? There is certainly an argument that in the name of state rights, right, a California or an Illinois or a New York, not likely in Ohio, right, but can assert states' rights against that encroachment, right? And so I don't want to be glib in saying, just again, coming back to where it is and whether you're a blue or a red state, but I think it is an important check. So in fact, I think just yesterday, or maybe it was Friday, the state of Oregon, a federal judge in Oregon, held that President Trump's sending in federal troops to the city of Portland was unlawful. Much of that, is predicated on the 10th Amendment, right, which says that any of these rights and powers that are not allocated to the federal government go to the states. And so this was an intrusion of states' rights, really a federalism concern. It's also issues of posse comitatus and federalizing troops. So it's a delicate balance, I guess I would say. So I'm somewhat of a hedging response, but I think when you have a powerful federal government, and again, a very aggressive federal government, the notion of federalism and states' rights can be an important check. We often think about checks and balances as being largely horizontal, that is to say, the court, Congress, and president, but there is a notion of vertical separation of powers. We have local, state, and federal government. But again, depending on, reproductive rights can be an example where that might seem less attractive, depending again on where you sit. Thank you. Should I do the call?
Thank you for an excellent presentation. I'm deeply offended by the boats that have been blown out of the water for purportedly carrying drugs. I'm amazed that there's no great outcry. Sandusky, Ohio became a great city when it was importing scotch during Prohibition. That's been a tradition in this country, I'm afraid. So is there no international court, first of all, that will address this issue? And why do you suppose there is no outcry over what is to me just outright murder? There is no due process. There is no accusation and evidence presented. They're simply killed. They may very well be carrying drugs, but it disturbs me that we have completely abandoned the law in this area. Would you comment?
Yeah, absolutely. So that was actually my fourth example, so I apologize for shortening it. But right, we know of at least 4 instances where the president has blown up purported Venezuelan drug smugglers in the Caribbean Sea, asserting powers under the commander-in-chief authority, where all of these matters would seem, under any definition, to be things that could be subject to simply criminal law enforcement interdiction. There is not, I think, under any at least under the lack test, argument that there is an armed conflict with these individuals. I haven't seen anyone accept that rationale, but it is on that basis that the president is blowing up these boats. It is a violation of international law. It is a violation of U.S. domestic law on a number of levels. I don't think there's any question. Why there hasn't been any outcry or more of an outcry, I don't know. I mean, it is my unsatisfying answer. I do think we certainly, I mean, this is me being, an armchair psychologist for the American populace. But I do think in our zeitgeist right now, there is this doesn't seem a radical statement to make, right? A profoundly xenophobic and anti-immigrant position. And that identifies people who are not American as the enemy, as exercising an insurrection of this country, right? That is the philosophy of this president. That is the ideology of this administration. And I think it is something that has captured the imagination of many people. And I think that fits within a continuum. That's a psychological, popular culture, if you will, analysis. That's not a legal one by any means, but I think it is how somehow people are accepting of this. And then it is just this notion of flooding the zone. Right? I mean, that so much action is happening that I think on a normal day, in a normal year of a president, right, that would be above the fold news stories, if you will. And it's not right now in this era, right? I mean, you miss it. But the other is, I would say, even though, of course, it's gotten a lot of attention, the president has put it up on, whatever various social media platforms, it's also been done quietly. And what I mean by that is, recently there was a news story now explaining some of the legal rationale behind this, right? But there has not been there've been barely, 2-page letters to Congress under the War Powers Resolution Reporting Act of what's going on. But there's really been very little information. So it is the president being reticent to share and purport to say these are secretive matters that are only the matter of the commander-in-chief. And it is Congress, right, not doing its job of effecting oversight, of saying, like, look, if you want to say there's going to be a war, who declares it? Congress. Now, I don't want to pretend the United States has been involved in scores of military engagements that have not had a congressional authorization of war. But here, it's not even a close call.
Thank you.
I've been looking at some of the Gallup information on Democrats versus Republicans. And right now, it's as of July, when I looked at the numbers, they were about evenly divided between Republicans and Democrats. Either leaning toward or identifying with on some level. That takes in the independent voters. I'm wondering, what do you think will really cause changes in that half-half part of our democracy?
Yeah, I again, I know we're always going to veer into the partisan. I don't know. I mean, again, I think, as I say, there's an element within the zeitgeist right now. And again, it's not just the United States, right? I'm sure many of you have read, right? We see this globally, right? A trend toward and favoring of autocratics, regimes, of an anti-immigrant sentiment, a deeper seated nationalism. And gosh, this administration has tapped into that, right? I mean, it really has seen something. And so I mean, how is that overcome? I'm a little bit at a loss. I mean, I certainly would say, I mean, I think there's been this, Monday night analysis of the election that actually talking on these issues, even as we're doing today, and that's how I make my bread and butter, is not effective. Right? Speaking in terms of, Constitution adherence and democracy is not going to move the needle. Now, again, I'm only citing analyses that are not my area, but I'm sure you've read them too. Certainly notions of the economy being more sensitive to how people are being affected, a certain economic populism, if you will. Certainly seems like there's some currency to that. And I don't know. I mean, certainly there are certain measures that have been taken by Congress as well. There's speculation that some of those will have an adverse effect on those who are least fortunate. And will there be a response to that? I'm left with, in some ways, and it feels a little bit of just a repetitive, just you got to vote. You got to vote, you got to vote, you got to vote. And notwithstanding that there were changes in the voting patterns that I think were surprising to many, a certain embrace of Trump by certain segments of the population that was surprising. There's still a heck of a lot of people who didn't vote. And in the end, this was a very close election, which I think can be forgotten. And one that was fraught in many ways that I don't need to tell you, that actually didn't have anything to do with Trump. So, that would be my positive spin. My worry, frankly, on the electoral side of things, though, is, of course, what we're seeing with issues of gerrymandering and politicization, potential removal of certain racial protections in the voting system. So I really worry about that. On one hand, I just say voting is the answer. The franchise is what's going to change things, but not if it becomes truly rigged in really ways that are problematic, I think, wherever you sit on the aisle.
Thank you for joining us this morning and sharing your insights. I'm still trying to wrap my head around the Unitary Executive thing and the Supreme Court decisions all the way through, which largely protect property and men. But the Unitary Executive thing, to me, it's almost like there's this mindset of a corporate situation where you have a board and you have an executive, and the executive is responsible for everything, hiring, firing, policy, all that stuff. And it's all in this like little board that does this. And I don't see the analogy applies.
Yeah.
So what is the legal, if there is, basis for what some argue the president is doing right now?
Yeah, so I love the way you framed it. All right, so let me try and make the best good faith argument. It is that there's only one person in the whole country who's elected by the whole country, right? And it's the president. So in some sense, he is the most democratically representative individual in the country.
Electoral college?
What's that? Well, notwithstanding that, right? This is true, but in most instances, barring that one, or maybe two instances, right, is even popularly elected, right? President Trump was popularly elected, right? And with that power comes the authority, and it would have applied to a President Biden or a President Clinton or a President Bush, right? that they should be able to set policy. And they should be able to choose the people who are going to affect their policy, right? And not be, right, restricted by various intrusion by Congress, right? Which, because it's the executive domain, right, so to speak. And so the only way, the only restriction that under the fullest unitary executive is they get to help appoint, right? They approve appointments of various high-level officials for those independent agencies. But other than that, we want the president to be able to affect their policy, and they shouldn't be fettered in any way, right? Now, the downside on that, right? Obviously, the argument, I think, is some of what you're suggesting, right? We have this, a good example would be the president's removal of the Bureau of Labor Statistics head, right? The president will, without any fetters, without any restriction, right, cook the books, right, and not want to, and we are in a vast enough system, right, where we want experts, we want independent checks. That's the way the system should be. But I think in its purest form, right, the argument is that Congress is actually over its skis. It has no business I mean, it's a separation of powers argument to some extent, right? It's Congress now interfering with the executive, right? And that this is really the domain of the executive. It, at its heart, is an argument, frankly, I mean, at its purest form, against the administrative state, right? It's walking back effectively everything that came about, you know, the Great Depression, right? And where we have sort of all these government agencies, right? There is a core belief by some members of the court and some scholars, right, that the administrative state is unlawful. We've got 3 branches of government, and the administrative state is a 4th branch that's not answerable. So the EPAs and FTC are problematic. The whole issue actually on the Federal Reserve is really interesting as an exception that the court seems to recognize, which in some ways gives up the ghost, if you will, on everything here. Because basically the court has effectively said, in all instances, there should not be any kind of restriction on terminating agency heads, except in the case of the Fed. I mean, we don't have full articulation from the court yet, partly because of this emergency docket. But what that suggests is the court even recognizes that the world would be terrified at the prospect of an unchecked President Trump affecting all monetary policy, which again, US monetary policy really does affect the whole world. And so it seems to be creating this odd exception that doesn't have a constitutional basis. There might be a good functional argument, right? For there's got to be some restriction on the Fed, but not on the Federal Trade Commission, right? And not on various other agencies.
Basis for requiring loyalty oath in an executive branch in the administration?
No, and I would say it's anathema to the Constitution and the First Amendment.
What effect, if any, would term limits on Supreme Court justices have on finding things or making things more equitable?
Yeah, I think it's a terrific idea, term limits. I mean, partly in the most charitable form, right? Even just the nature of happenstance and the way things go about, you can have a court for a very long time take on a certain bent, right, and rule in a certain way. And in general, term limits themselves, right, provide some sort of check, if you will. At its most extreme, though, you can see presidents and Congresses go along with figuring out ways to deny the appointment and sitting of justices appointed by one party and not the other, and you get really an imbalanced majority. So I think term limits, and there have been proposals by both sides of the aisle. In fact, one of the founders of the Federalist Society, Stephen Calabrese, provided a wonderful proposal that effectively suggested there should be 18-year terms for Supreme Court justices. They would sort of go through, effectively every president would then therefore get to name, I think it was 2, maybe it was 3 court members. Now, you could still run into issues if you, of course, have a president, right, from only one party elected. But at least under that format, right, we sort of create its own check mechanism, which I do think is integral to, at a minimum, both the structure and the spirit of the Constitution.
How do you come up with 18?
I honestly don't know. Every time, there you go, right, there's the math. Thank you.
To look at the time here. mindful. Absolutely appreciate
Thank you.
it. And I want to emphasize, this is our first forum on democracy, which is what we're talking about the rest of the fall. Upcoming topics include authoritarianism, immigration, diversity, and more. We have forums at 9 o'clock every other Sunday until December 7th. Our October 19th forum will cover tariffs and their impact on individuals, our economy, and national security. I want you to attend, I want to invite you to attend our 10:15 Sunday service upstairs in our sanctuary or on our YouTube page at our website, ucleveland.org. Reverend Randy Parteen's sermon today will cover how we can personally define our responsibility in addressing the different places and ways that oppression and fear dominate our culture and our environment. There is much suffering and need surrounding us. How can we prioritize our individual responses to these issues? Thank you for joining us.